But I just kind of want to briefly go through the outlines and highlight some of the differences in practice between the three counties, starting with Oakland. Oakland County, when you file your complaint for divorce at the clerk's office, you need to include a summons with it, unlike Wayne County, where a summons is generated by the computer. You do not need to present with you the record of annulment that gets filed with the state, record of annulment or divorce form, but you do need to do that in Macomb County. So in Oakland, essentially what you're doing is you're filing your summons and your complaint. You need to, at that time, have any ex parte orders ready that you want to present to your judge. And once you have filed, and of course if it's a DM case, you're also filing the verified statement for the friend of the court, and you pay your fee, you get assigned your judge, and then you can take, and Oakland, like Wayne County, has the computerized barcodes. You'll get some of those. What you need to do then is take a copy of your complaint, just your complaint and any proposed orders, to your judge's office where you drop them off. And in my experience, the turnaround on presenting ex parte orders in Oakland County is about 4 or 5 days. But you want to get those orders in, and be aware too that one of the really hot button issues for family law attorneys is this very controversial practice that a couple of people out there who have given the rest of us a bad rap have, of going through all the recent filings and then soliciting business from the person that you're suing on behalf of your client. So if you represent a wife who's been beaten, there's a possibility that some attorney is out there who's going to pounce on the new filing, contact the husband before he's been served with a PPO or any kind of restraining order on property or status quo order for household support, and he's going to be tipped off. I can tell you as a practitioner, it's a lot better when you can walk your orders through and get them served sooner rather than later, because you've got to file your complaint to present the orders. Once that complaint is filed, your client is vulnerable. Be aware that there is that gap in time that varies from county to county, and there is risk that is involved with that. Naturally, you can't serve your client's spouse until you get back any orders that you've presented. And so when you do, you're serving in all counties. You're going to be serving, obviously, your summons, your complaint, and any orders. But also in Oakland County, with your complaint, you're serving the early intervention conference and SMILE attendance order. The early intervention conference is certainly a required step for the client, and in most cases, certainly where there are 2 attorneys involved, the attorneys also attend, and it is an opportunity for your client to become somewhat oriented to how the court system works, how the family court works, how the friend of the court works, become familiar with who the staff is. Although we also have, and of course the public has access to that information at the Oakland County website, it really brings it more down to reality, and questions can be answered, and the referee gets an opportunity to meet the parties and become familiar with what some of the issues in that particular case may be. Some of the things that can happen at the early intervention conference now are that a domestic scheduling order, at least a preliminary one, can be issued. However, be that as it may, there is a settlement conference date that is assigned that, regardless of whether we get a domestic scheduling order or not, in my experience, the judges across the board still require us to appear for that early, for the settlement conference date, and that would be the, obviously in the cases involving minor children, because you're not doing an EIC in cases where there are no children involved. In DO cases, unless you have motion hearings, your pretrial date is going to be the first time you appear in front of the court, and if you've got a settlement and the statutory period is run, you can finalize your case at that point. If not, one thing that I think it's very important to be aware of is that the DO cases in particular are on a very fast track, and this is true in all 3 counties. And in the event that you're representing parties who have either no minor children or adult children and who are in long-term marriages where there may be, even now, considerable assets, you need to ask for additional time, and that's the time to do it. When you go in for your pretrial, if you've got, I've had a number of cases over the years where parties have been married 25 or 30 years, the kids are adult, and you walk in and the judge says, well, there's no kids, you should be ready to go, and we have to explain, Your Honor, this is a long-term marriage, there's going to be a battle over alimony, we need to do some investigation as to the retirement assets. They've got 3 properties they have to be appraised. We need some additional time. And I've never had a case where we've had a problem getting that time, but you have to make that request, and you have to be aware that just because there's a DO at the end of the case doesn't mean that you're going to get it done in 60 days. On the other hand, if you can, then you can finish up at the so-called pretrial date and you're done. And although the nature of what the various counties call this particular hearing, whether it's pretrial, settlement conference, status conference, case management conference, which is what it's called in Wayne County, the step that you're taking is reporting to the court with your client, identifying for the court what the unresolved issues are in your case, getting an idea of how long it's going to take to complete the case, getting dates for completing certain activities such as discovery, appraisals, getting witness lists filed, going to mediation. All of these things are handled by docket control in all 3 counties, with the exception of Macomb County. In my experience, we are expected to bring our clients even in Wayne County to case management, where we often don't see the judge. We are always told we need to bring our clients with us. And in Macomb County, the difference is that the status conference, as it's called there, is sometimes handled by a judge, but is often handled by the judge's referee. I just want to touch a little bit on the issue of evidentiary hearings. MCR 3.215B2, which is cited in the materials, gives the court discretion to either hear a matter concerning support or parenting time, custody, change of domicile. It also gives the court the opportunity to exercise discretion to have it heard first by a referee. And oftentimes the judges will ask the attorneys what our preference is. My own feeling is unless you have clients who have unlimited resources, it's better to go right to a court, even if it means waiting a little longer to get a hearing date. Because invariably, if you can't settle a case before you go to hearing in front of a referee, you can't settle a case. And that means that somebody's going to come out of that referee hearing unhappy, and they're going to invoke their right for a de novo review. I just want to touch very briefly on the websites for the 3 counties. All 3 counties have websites. The Wayne County website needs a lot of work. It's not the best place to go for resources, but if you're an improper, there are a lot of forms that are available there. If you're an attorney, the one link there that's absolutely invaluable is the attorney line. There is an attorney line where you can get through to a real person at the front of the court, discuss your issues, get at least directed to the proper person in the right place to get your problem solved or your question answered. You can also utilize a specific email that's set up for attorneys. I've used both of these resources. I've never had a problem. Oakland County has probably, I mean, this is a subjective opinion, but the best of the 3 in terms of its family court website. There are forms available, there are procedures, there's a list of staff for all the judges. There's just a wealth of resources and information available there.